When do you settle a personal injury case and when do you take it to court? Well, a settlement just means, as most people know, that you and the person who caused you harm, or more likely than not, their insurance company, agree on some number. They cut you a check and you release all claims. Done. So, why would you want to do this? Well, there's a few good reasons to settle a case. Reason number one, speed. It's oftentimes, if everybody knows the extent of the liability damages, things like that, you can reach a settlement far more quicker than if you want to go take a case to trial, wait for a verdict, and then potentially appeals. So, speed is a great reason to settle a case. Number two is certainty. When you and the other side are working out a deal, you're going to come to some number and you're going to know exactly what the number is, and so will they. If you go to trial, you're going to be depending on a jury to come up with the right answer. And sometimes the juries do that, and sometimes they don't. So you've got an element of randomness if you go to a trial as opposed to just settling a case. And third is lower costs. If you settle a case, you might do it early on where there's not a ton of costs in the case. But if you're going to take something through discovery and through trial, when you get to trial, you might have experts that are thousands of dollars. Your lawyer's contingency rate's probably going to go up. So your lawyer's going to cost you more money. You may have jury fees. You may have exhibit fees. You may have court reporters. So even though you may get a trial verdict that's higher than the settlement number, well, all those extra costs of trial might eat up the difference. So it's important to look at the pros and cons of whether to settle or whether not to settle. But what about when should you not settle a case? Well, there's a few cases you're probably not going to want to settle it. The first one is fair compensation. If the settlement offer is significantly less than what you deserve for your injuries, going to court might be necessary to get the insurance company to pay the right amount. You're going to get a verdict and they're going to have to pay the verdict or they're going to have to appeal it, which is going to cost them a ton of money. So if you've got a really, really low settlement offer, you might have to take it to trial and not settle the case. Another situation is when you've got great evidence. Liability maybe is not disputed, damages are known, and you're not really getting anywhere. If this is a case your attorney thinks a jury is going to really, really, latch onto, you may want to take that out to a jury. And then the third is precedent. Sometimes there's cases where people want to set a legal precedent that's going to benefit other people in their same situation. And if you settle a case, oftentimes settlements are confidential. So if people want to know what happened in your particular case with your particular set of circumstances, they're not going to be able to find out because it's a confidential settlement. But if it goes to trial and there's a verdict, then it becomes public. So if there is some sort of important precedent you may want to set, that would be a time to think about trial. So ultimately, the decision of whether you're going to take something to trial or settle is yours. Definitely consult with your lawyer, find out the pros and cons of each. If you happen to have this sort of mental wrangling going on in your head and you're in Nevada where I practice law, feel free to give me a call or drop me an email and we can talk about it.